Welcome. We are visiting the values of the Constitution of India. The Constitution of India has given continuity with its past, the entire set of laws, the whole range of institutions, the complete functional apparatus, including the persons occupied the chairs, individuals in one form or the other being vested with any of the powers, functional powers, authorities, duties under the constitutional apparatus stands recognized and given a sanctity, and there has been a continuity. We, the students of the values of the Constitution of India, when in the light of this continuity clause, explore and go back to the roots of each and every value adopted, accepted, continued by the Constitution of India, when takes us to the jurisprudential values, criminal justice values, then certainly it brings us face to face with the trials, the criminal trials conducted prior to the commencement of the Constitution of India. And it is here in this context, this date, 7th of December, in itself is having a great value. This value is in the context of the trial of Bhagat Singh, Shaheed-e-Azam Bhagat Singh. All of us who want to initiate ourselves properly in the jurisprudential values sanctioned under the Constitution of India shall initiate oneself by being face to face with the different features of the trial of Bhagat Singh. I am taking a book of Nurani, senior advocate, and he has given a title, Politics of Justice. Therefore, in the context of justicing, in the context of criminal justice system, in the context of jurisprudential values under the Constitution of India, we have to have this aspect also in our mind, as that word adjective can be attached to justice as well. Politics of justice, what it means, will be clear to us in a glaring form if we will be through the trial of Bhagat Singh and the ultimate judgment and fate of Shaheed-e-Azam Bhagat Singh. All of us, when go back 9 decades in 1930, then we will be understanding as to how big change has occurred since then, but still, which of the foundational values are still there, inherently surfacing at one layer or the other, which brings us conscious as to how much politics gets attached with the justice. One shall be through this young man's contribution, how big a role stands played by his sacrifice. Therefore, first of all, let us have some idea about the chronology. Date of birth of Bhagat Singh is 27th September 1907. The last day The day of sacrifice, the day of execution is 23rd March 1931. Just 23 years and a half in all. This young man, this brave young man, Shahid-e-Azam, lived mortal life for 23 years and a half only. And during this short period, how much awakening, how much enlightenment is there with us because of this young man is still to be evaluated. We, the Indian, are not that grateful to the sacrifice of Bhagat Singh. We are still awakening. We are still having little bit consciousness of the contribution of the sacrifice of Bhagat Singh. During this period, he was engaged. Parents were insisting for marriage. It is during this period that he had completed his schooling, had entered college, but the college which he finally joined was the path, self-invented path for having liberation, attaining freedom. The path which he adopted, the schooling which he had is much different. It is much, much different than what we, the present generation, at the age of 23, are acquiring. Our schooling, our choice of path, our decisions, our goals, our motives are certainly of darker face before Bhagat Singh's light. Now, this trial is a trial of Indian Penal Code. This trial is the trial of Code of Criminal Procedure. This trial is the trial on judicial side. This trial is the trial which well indicates as to how at the highest level every step was taken to have complete distortions for the formation of the court, choices of the judges, the procedural adaptation, recording of evidence, interpretation of evidence, the right to appeal, etc., etc., each and every aspect of the trial of Indian Penal Code offences under the Code of Criminal Procedure has been deviated, stands distorted. Therefore, we as lawyers, we as students of law, we as aspirants of the jurisprudential values, we as idealists, we believing in the core values of the Constitution of India have to sit comfortably. We have to read each and every word of the judgment of the special tribunal announced on October 1930 in this particular trial. Before that, first we shall draw a contour, we shall draw the outline, we shall have some idea of the chronology. And we may begin with 30th October 1928. It is the day of procession in Lahore. Lala Lajpat Rai was the central figure of this procession. What happened in this procession is the phenomenal event, and this phenomenal event had effect upon everybody, including Bhagat Singh. Then 17th December 1928, the another phenomenal event day, as on this day murder was caused in Lahore. It was of British police officer. It is with respect to this murder that the trial of Bhagat Singh resulted into death sentence. 8th of April 1929 is another phenomenal date, as on this date bomb was thrown in assembly in Delhi by Bhagat Singh and his associate. Then 12th of June 1929 is another fateful phenomenal date, as on this date judgments was announced in Delhi bomb assembly case, and Bhagat Singh was awarded sentence. A month thereafter, the trial of the murder of December 1928 had commenced. It is on 1st of May 1930 that ordinance was promulgated by the Governor General of India, as that the trial of this murder against Bhagat Singh and his associates will be conducted by a special tribunal. It is this individual single step which in itself will help us appreciate why the author has added the adjective politics and stated it to be this narration, this evaluation of this trial as politics of justice. How the government of the day had exercised, misused the powers, promulgated the ordinance, and took the trial as to be tried by a special tribunal. The way the members of this tribunal, of this commission, were selected in itself is a matter of great concern for the fair trial expectations. Therefore, while we shall be analyzing, while we shall be appreciating different aspects and different features of this trial, then our focus is certainly to remain as much as upon the promulgation of the ordinance, as also upon the way the particular members of this commission were selected and appointed and entrusted the responsibility. And also here in this context, it will also will come to prominent focus as to one of the members of this commission who was removed in between. All these aspects are of great concern. The judgment of the commission is a very prolonged one. It runs over hundreds of pages. The witnesses are also hundreds in number. The documents exhibited as well are hundreds in number. However, when we will be having a glance of these enlistments, then it will be evident as that ultimately the judgment focus is centered around the approvals. All those who have been given the concession of pardon on the plea of confessions, or what is the law of approvers, or the standard of justice of proof beyond all reasonable doubts, or the evidence of independent witnesses test, etc., etc., have been sacrificed is to be appreciated, is to be evaluated. The complete judgment as such is not there in this book. However, this book otherwise has analyzed this judgment, and also this book is giving us insight as to how the tribunal conducted, how the tribunal was in a hurry, how the tribunal had sacrificed the basic fundamental principles of fair trial, how the defense was not permitted, etc., etc., are the features which deserve to be appreciated by us. All what I can say today is that let us be through this book. Further, let us try to lay hand at other descriptions in the public domain. As far as the full judgment is concerned, the same as such is not traceable in the public domain. Let us try to reach the sources possible. But certainly, this judgment is with the author and others. If this judgment is made in public domain, and if we have the first visit to this original document, then certainly we will have more and more insight about it. The autobiographical and biographical descriptions of Bhagat Singh and his family, about the philosophy of Bhagat Singh, about his writings and expressions in the form of diaries and letters, etc., etc., as well, are the prime source in terms of which we have to evaluate the personality of Bhagat Singh and also the way he participated in this trial. The trial, which in one way was concluded in terms of the judgment of 1930, in fact, is still continuing. From the date of judgment to date of execution is the period in which many facets of this happening had come to light. And from the date, rather the exact day of execution, a day before and day after, as well, are the fateful events in our history as the Congress session was in progress. And this fateful date, this fateful event, this happening otherwise also becomes phenomenal as Mahatma Gandhi was consciously in participation. There are full-length expressions as complete chapter in this book, conveying and concluding as that Mahatma Gandhi, father of the nation, was not truly truthful in his conduct and expression as to the way he had put the case of Bhagat Singh with the British authorities. In any way, this event since 1931 till 1947 is a continuity of the trial of Bhagat Singh, but trial has not ended with attainment of the freedom. As from 15th August 1947 to 26th of November 1950, 26th of January 1950 as well, we had a clause of continuity with the past history and laws. But is it that we have done justice to such sacrifices at all? The chapter of fundamental duties, which is having a duty upon us to imbibe the values of freedom struggle, was not there in the constitution as was originally drafted. And then whether since addition of the chapter of fundamental duties casting a duty upon each one of us to imbibe the values of freedom struggle, is it that we are sincerely and consciously reminding ourselves about the values of the sacrifices of this class of Bhagat Singh as well or not? That also is on trial. And till date, whether we are bold enough and whether we have been honest to ourselves and whether we have recognized Bhagat Singh as Shahid-e-Azam, what are the records, what are the recognitions, what are the awards, recognitions, etc., bestowed upon different personalities, whether that list includes the list of Bhagat Singh as well or not. Bhagat Singh and Netaji Subhash Chandra Bose are two pillars, two index, two pole points in reference to which we have to revisit the political trials. And the trial of Bhagat Singh, in my view, is still continuing. And when in 2030 we will be having 100 years completion, I think this trial is to continue till that date. Let us start revisiting, let us start reappreciating, let us start re-evaluating, let us start revisit to the values of the Constitution, and let us complete the trial of Bhagat Singh. Let us imbibe the values of sacrifice of Bhagat Singh. The day Bhagat Singh was executed, the goddess of justice started weeping, and goddess of justice is continuously weeping till date, and goddess of justice will continue weeping till we the Indians till we the human beings, till we the liars, till we the exponents of law, till we the scholars urging for the jurisprudential values will be giving a final say as that yes, Bhagat Singh was given injustice in the name of a justice. Thank you very much.
Thank you, sir.
Thank you, sir.